Welcome back to Conversations with Jennifer. Jennifer's an estate planning attorney, and today we're going to talk about the two most important considerations you should have if you're a single individual and you're kind of planning, doing estate planning, and you have a lot of uncertainty around that. And so, why don't we start there, Jennifer? So, what are the two most important considerations when you're doing estate planning when you don't have a natural heir?
Correct. So yeah, you don't have, someone who like a spouse or a family member who, instantly comes to mind in order to either receive your assets or help you take care of your life. So really the two biggest things are I'm alive, but I can't make my own medical decisions or financial decisions. Who's going to help me as a single individual with that? So putting documentation in place helps you while you're living. And that's really the most important thing. Oftentimes people think about, well, what's going to happen when I die? The really critical part is what's going to happen if I'm still alive, but I can't manage these things for myself. So putting together a healthcare directive where you're designating the agent who's making medical decisions for you, and then putting together a financial power of attorney, again, listing someone who's going to be making decisions for you. The hard thing about both of those documents is those are personal estate planning documents. And oftentimes, or for the most part, corporate trustees, banks, they do not like to be involved on these documents whatsoever. So while they may be a good option as an executor in your will or the successor trustee on a trust, they will not act on a healthcare directive or a financial power of attorney, really under any circumstances. Sometimes they'll do a very limited power of attorney, but for the most part, they don't want to do that. So figuring out what your other options are is really important. So one is there are individuals out there who it's their job to act as a professional or private fiduciary. And so those individuals have a background in the estate planning world, but have chosen to make it their career to act as a fiduciary. And they will oftentimes act as an agent on a healthcare directive and a financial power of attorney. But again, keep in mind, these are your personal decisions while you're still alive. So you really want to meet with these people and make sure it's the right fit. The other option is like a trusted friend or colleague that you've known for a while. They may not be a blood relative, they may not be a spouse, but they may be a good fit for kind of more those personal decisions and those personal documents.
Yeah, and even with the trusted friend, you don't want a friend that's your age, right? You want to have a friend that's probably 10, 15 years younger than you so that they can be there when you need them. Right,
correct. And you want to have those conversations with this person too. You want them to know they're your person. So having conversations, although they can be awkward or uncomfortable for some people, they're really, really important and critical to have. So and then I'd say the next really important thing is if you don't have an estate planning document in place when you pass away, here in California, the California Probate Code is basically going to confirm who's going to receive your assets. You don't have a will, you don't have a trust, didn't complete beneficiary designations, you basically did no estate planning. California law is going to decide who gets your assets. And it's basically your nearest heir at law. So it's going to go up and out your family tree until it finds a living heir. And with some people, it could go all the way out to second, third, or fourth cousins, like people who you really have no relationship with. So that's probably not ideal or the direction you want to go in. So sitting down, and again, it could be a simple will, it could be a trust, it could be a beneficiary designation, depending on the type of asset we're talking about, but confirming who's going to be receiving your assets when you pass away so that California won't make that decision for you. Sometimes it's family members still. Sometimes it's friends. Sometimes it's charity. So sometimes single individuals want to make sure that a certain amount of their estate goes to charity, and they can, make that decision through their estate planning documents. Retirement plans are great vehicles to go to charity because of the income tax implications with retirement accounts. So those are really powerful, great assets to go to charity. But obviously, the individual needs to be charitably inclined. So walking through who's going to be getting your assets so that California doesn't dictate that is really important as well.
Yeah, and for those people that are charitably inclined, one of the things that may come across is, do I want to give this large lump sum to these charities all at once? So one of the things that we do within our practice is we'll set up a donor advised fund to receive non-retirement type assets.
Yep.
And then from that donor advised fund, kind of create like an endowment or a stream of income to those charities over 5 years. And so it's more of a spread out income approach to the charity, so they don't get overwhelmed with a lot of dollars in 1 year and then back to their old operating budget. So they can plan out projects, as well as for you in having that reoccurring gift go out.
Correct. Yeah, no, I think that's a great idea, Amar. And that, if it's set up while the individual's alive, then they can get it going and start working with the institution where the donor advised fund is at, and put a plan in place as far as the types of charities they want to receive the funds, and get it moving while alive, or you can wait until death and have it put together at your passing. So there's a lot of options on that as well.
Perfect. So two big considerations while you're alive: who's going to help you, with medical decisions as well as financial decisions, right? Typically we pick friends that are at least 10 years younger, or nieces or nephews if they're in the area. And then if you don't have anybody, then you can look at a professional fiduciary or a private fiduciary. And then, when you do pass, how do you want to distribute your assets, and making sure that you have a basic will or a trust, or naming outright the charities or individuals through TOD and POD. Mm-hmm. Thank you for watching this quick video. If you like this type of content, please hit like and subscribe. It helps other people find these videos. And thank you, Jennifer, and I'll see you next time.
Thank you.